Everyone, Joe Gentili from Saroff Gentili LLP. So I think a lot of the conventional wisdom out there on consular denials is no longer correct. So the conventional wisdom is that if you have your immigration case decided by a U.S. consulate and the U.S. consulate denies you, that is pretty much the end of the road. The consulate's decision is final, and there's really nothing you can do to contest them. They're bulletproof, and that's because there's this doctrine that exists in the law called consulate nonreviewability, which says that the decisions made at a U.S. consulate overseas are not reviewable by federal judges. That basically what they say is final. And I think if you talk to a lot of immigration lawyers, and you ask them about consular non-reviewability and what you could do in the event of a consular denial, they may have some strategies to suggest, but contesting the consulate's decision would not be one of those strategies. And that is now out of date. Last year, there was a decision in the Ninth Circuit Court of Appeals. So the Court of Appeals in the U.S. are the courts that sit, they're appeals courts that sit just below the U.S. Supreme Court. And so they're very high-level courts. And that court, the Ninth Circuit, which covers most of the Western United States, had a case go before it called Munoz versus U.S. Department of State. And in that case, there was a U.S. citizen attempting to bring their spouse to the U.S. Consulate denied them the ability to do that, and they had basically very thin, unexplained rationale as to why they were doing it. The Munozes were largely left guessing and not given really any satisfactory answers. And the Ninth Circuit Court of Appeals said that, okay, we understand there's this general idea of consular non-reviewability. However, when a U.S. citizen's constitutional rights are implicated, well, that's always reviewable by federal courts. And so if you're gonna, if the government is going to take away somebody's constitutional right in some way, then that person is entitled to due process. And so if you're a U.S. citizen looking to bring over your spouse to live in the U.S., well, that's a fundamental right to liberty, essentially, to live with your spouse. Or if you have a minor child that's a U.S. citizen, they have a right to liberty to live with their parents in the U.S. So if the government is going to deny them that right, then they have to provide due process. And therefore, if there's no due process provided, if, like most consular denials, you get one sheet of paper, maybe with a checkbox citing a law saying, sorry for citing this law, you're denied. Well, that's not good enough. Can't take away somebody's constitutional rights without giving them a more fulsome explanation and just a more robust process before doing that. So that decision that in Munoz saying that if the consulate's going to take away your constitutional right to live with a close family member if you're a U.S. citizen, there has to be due process. That opens the door for reviewing what the consulate has done. And that opens the door to reversing decisions, especially where the decisions are sloppy or there's just egregious mistakes in them, which are pretty common. We've filed a few of these cases. We've had good success with them so far. Obviously there's no guarantee of success with these things, but what this Munoz decision provides is an avenue, a real avenue and a real tool to fight these denials where previously there was none. And that tool exists. I think Munoz lays out a roadmap that you could apply this theory at any court in the U.S., but where it's most strongly going to be applied is in the Western United States. So the states that fall under the Ninth Circuit, Munoz is controlling law for them. So if you were to file a case in California, for instance, the district court judge in California has to follow what the Ninth Circuit says. So these cases are particularly strong in those areas that the Ninth Circuit covers. So this is some really, I think, some really good news for people for a situation where they have these consular denials that are just absolutely devastating, because they separate families, and where there was really no hope, now there is some hope. Now there is a way to fight back. So that's great. I don't think the whole immigration bar has caught up yet to the fact that this exists and it's a viable path. But I suspect it will, as kind of good results kind of pile up over time. So as always, any questions, please feel free to reach out. I hope you enjoyed this video, and if you did, please subscribe. Thank you.